Good morning, everyone, and welcome to the 36th meeting of the Net Zero Energy and Transport Committee for 2025. I'd like to welcome to the meeting Sarah Boyack, who will be attending as the substitute member for Monica Lennon for items 2 and 3 on the Ecoside Bill. Under Rule 9.13a of our standing orders, Monica Lennon is not entitled to exercise the rights of a committee member in relation to these items. This is, of course, because she is the member in charge of the bill. Monica will, however, be present for the evidence session on the bill, and like all members of the Scottish Parliament, she is entitled to ask questions, and you will get some questions, Monica, at the end of this, the committee questions. Item 4 today is consideration of our work programme, and we'll not discuss the Ecoside Bill under that item, and Monica, rather than Sarah, is entitled to take part in that. And I mention all of this just purely for transparency, given that we may agree, subsequent to this, to take items 3 and 4 in private. So our first item of business this morning is a decision on taking items 3 and 4 in private. As just stated, item 3 is consideration of today's evidence on the Ecoside Scotland Bill, and item 4 is a consideration of our work programme. I'm going to split this into 2 questions to make sure that I don't break any of the Parliament's standing orders. The first I'm going to ask is whether we take item 3 in private, noting that Monica Lennon may not participate in that decision, and Sarah Boyack may take part in that decision. I'll then ask if we agreed to taking item 4 in private, and Monica Lennon may take part in that part of the vote, but Sarah may not. So are we agreed to take item 3 in private? We are agreed. Are we agreed to take item 4 in private? We are agreed. Good. Our second item of business is an evidence session with the Scottish Government on the Ecoside Scotland Bill. This will be our penultimate evidence session before we hear from Monica, the member in charge, next week. And I'm welcome to the meeting Gillian Martin, the Cabinet Secretary for Climate Action and Energy, and her supporting officials. There's Charles Stewart Roper, who's the head of the Environment Strategy and Governance Unit, and David Murdoch, the Solicitor for the Scottish Government. Thank you for attending this morning, Cabinet Secretary, and I think you want to make some brief opening remarks.
Yes, I just wanted to acknowledge the role that Monica Lennon has played in raising the profile of the importance of preventing serious damage to the environment, and to say that her consultation on the bill showed again that environmental crime are extremely important to the public, and it's absolutely right that we analyse whether we've got provision in law to reflect the seriousness of those crimes. I've had useful discussions with Ms Lennon as she's developed her thinking on the ecocide defence. Ecocide level offences are thankfully very rare, but there's an opportunity here for Scotland to be among the first nations to have an offence of ecocide in criminal law, and I'm supportive of the general principles of Monica Lennon's bill. Obviously, I'll consider the Stage 1 report from the committee, but hopefully today I'll also be able to outline some areas in which the Government would like to amend the bill.
Very much, Cabinet Secretary. And you've said that you support the general principles of the bill. Could you explain very briefly why you're supporting that, and explain why you support the member in relation to whether you feel there's a gap in Scots law as it stands at the moment?
So, I think initially, so I'm supportive of the proposal to introduce an offence of ecocide as properly understood as being the most extreme, willful and reckless cases of harm. Now, I was satisfied that the provisions in the Regulatory Reform Act were appropriate, and that did form part of my discussion with Monica Lennon initially. We suggested that amendment to the Regulatory Reform Act would have the same outcome. But I was particularly seized about the international campaign for the adoption of ecocide as an offence. But and the public outcome, of course, the outcome may be similar or the same in reforming the Regulatory Reform Act. But would an amendment have the same impact in terms of deterrence as a bespoke bill? And also, I want to make sure that obviously Scotland's always in line with EU law as well. And I think there was a good discussion between myself and Ms Lennon about that as well. So, being one of the first nations to introduce a bespoke offence will be providing a deterrent. And given that the bill has advanced to stage 1 and Ms Lennon's done all the work that she has, I was keen to support the general principles of it, albeit with some caveats. I don't know whether you want to mention some of the caveats I have in that regard.
I'm very conscious, Cabinet Secretary, that I don't want to tread on the toes of my fellow committee members who may want to dwell into that, so I'll leave that at the moment. Is there anything else you want to say on that?
Yeah, I mean, I did want to point to some areas of the bill there was a burden of proof on defence, which I don't think is in line with the placing an onus on providing the defence, proving the defence of the accused, and the usual burden of proof for all offences on the prosecution proving guilt. So I think that's something that needs to be looked at, and certainly I would be proposing to put amendment, because we don't think that the bill is currently in line with the ECHR in Article 40 of the UNCRC. We would intend to amend that part of the bill at stage 2 to make sure that it was compliant. Everyone has got a right to a fair trial, and of course the burden of proof has to be on the prosecution to prove guilt. And also I felt that the reporting requirement was unnecessary, and given the very, the ecocide is a very rare occurrence, thankfully. The financial memorandum itself actually identified the ecocide happening between 10 and 20 years. Yet there was a requirement for reporting every 5 years, which I didn't think was proportionate. So those two of the areas that I have concerns about. And I also, in terms of the dovetailing of it with the Regulatory Reform Act, and any prosecutions that would happen there, I wanted to float the idea, with the committee, maybe it's been also mentioned in evidence, that where there is a case of ecocide, I would also like to make sure that there also, if that wasn't provable, that would also be the Regulatory Reform Act and the offences contained within it would also be a component of any trial. Because ecocide, as it's written and as it's drafted in the bill, there's a great deal of, I think it's a very, very high bar, rightly. But what we don't want is people maybe not reaching that high bar, but feeling that they've got away with the offence that would be covered in the Regulatory Reform Act. So those are a couple of the areas that I have concerns about. And
I think we definitely heard, Cabinet Secretary, in evidence that the bar for a prosecution under Section 40 of the Regulatory Reform Act would be easier to achieve than a prosecution under an ecocide bill if it was passed, and therefore the option was to make sure you got your conviction, as it were, so you'd probably go for the Section 40. I'm sure somebody would dwell into that. But one of the things that I want to just push back a little bit on, Cabinet Secretary, so I understand, is in your memorandum you said there was quite a big overlap, or the Scottish Government felt there was quite a big overlap between the ecocide bill and Section 40 of the Regulatory Reform Act. And could you just highlight what those overlaps are and why you feel, or if you feel, whether the Section 40 is deficient and it needs another string to the bow through the ecocide bill? Well,
if I can put it in the terms of, I wanted to make sure, and I had discussions with Ms Lennon that important that they ensure that the offence of ecocide was additional. It was additional, a step up from what, and obviously I think that's where we need to look at maybe some of the definitions associated with what definitions of significant harm in the Section 40 in the Regulatory Reform Act, and the definition of severe in the ecocide bill, and what is the difference between those two things. I think that there's certainly been enough work done by the campaign in defining what ecocide is. Could we have gone down the route of reforming and making amendments to the Regulatory Reform Act? Yes, we could have. Would it have taken this? I mean, we are where we are. Ms Lennon has progressed her bill and has got an alternative vehicle in order to introduce the offence of ecocide. So I think the phrase 6 and half a dozen comes to mind, because we could reform the Regulatory Reform Act to include the offence of ecocide and to make it strong. But Ms Lennon has progressed this bill, and we've got an opportunity to have a bespoke offence of ecocide, which I would want to make sure would dovetail into the Regulatory Reform Act provisions and provide additionality.
Okay, and we'll see, I'm sure, during the evidence session if that's the way you perceive it. Mark, I think the next questions are from you.
So that dovetailing, can that take place within the context of this bill, or is there a need to go back and look again at the Regulatory Reform Act? If not under this bill, then going forward, I mean, does the RRA sit there, and can it quite seamlessly link in with the provisions within this Ecocide bill?
Yes. So if I just maybe come to some of my provisions about, hang on, I can explain this properly.
I think what you're saying is there's no need for amendment of the RRA as it stands at the moment?
Well, if Miss Lennon's bill is providing the additional offence of ecocide as defined, then that would be additionality to what's already in the Regulatory Reform Act. So, you know, there was, I mean, initially, I mean, I was concerned that there was a degree of overlap between the proposed new offence and the existing offence, and that was covered in our memorandum. It sets out, the policy memorandum that we put forward sets out a summary of the existing environmental law. We've got a full discussion of the existing offence of causing significant environmental harm under Section 40. And of course, there are already a range of offences that cover activities that damage the natural environment, and the committee will be aware of them. There has been various concerns of the committee about where both existing Section 40 and new ecocide offence are in the statute book. Prosecutors might be inclined to bring the Section 40 offence in most circumstances, as it's a strict liability, so easier to prove. So bringing the ecocide offence might be seen as a riskier option. That is why I am keen to, stage 2, if it gets to stage 2, to work on something that would actually genuinely provide for that Section 40 being taken into account and could be, in it, when it comes to court, if it's not met the bar of ecocide, it could meet the bar of Section 40, and for that to be included. I wouldn't want, you know, significant and severe to be the enemy of prosecuting, you know, serious environmental harm. So
I think we
a
had
formal
some
connection between the two offences through an alternative conviction provision is worthy of further consideration, is my point. It would provide for courts and juries to consider a specified lesser offence should they not be convinced that a conviction is merited under a greater offence, and that is something that could be done. And I think that that would address any kind of overlap, but I think it would also address any, you know, if you're prosecuting under ecocide and then it's not been able to be proven by the prosecution, but the offence is under Section 40, the bar is met there.
Okay, yeah, because I think, as the convener was saying, we had some evidence from Crown Office, Procurator Fiscal Service, that, you know, where effectively if they have to make a decision, you know, they may go down the Regulatory Reform Act route because the bar is lower, the chances of conviction are on the face of it, a lot higher. So it's just trying to kind of make sure that everything is, the options are available. And,
and I think that was my initial...
And somebody doesn't sort of drive a coach and horses through the provisions.
That was my initial concern when Monica came to me with the offence of ecocide, and obviously with the discussions with my officials who obviously know the existing law intricately. I was initially concerned, well, we've already got things in place. Is this something that's not going to be additional, or is this going to be something that is so hard, the burden of proof is so high, that people are, or organisations are accused of it, but we're not able to meet the burden of proof on it, and with that, you know, so that was a concern. And discussing it now that Monica's got to the stage where she's brought the bill forward, again, I come back to it has to provide additionality, but it also, in a way, can't cancel out. Does that make sense? The existing law that people could be prosecuted under. So that the ways to address this concern is something that we're working on in government, because what I don't want is effectively, well, the bar's so high that no one, terrible offences could be committed, but if it's not ecocide, then somehow it's not sufficient for prosecution.
Yeah, thanks for that. And I think we've heard also that where ecocide has been brought in other countries, it's very much seen as a standalone offence that really drives that kind of culture change throughout the whole regulatory system, and it makes a strong statement about the values of the country and the need to protect the environment. You mentioned that a little bit in your introductory comments, but do you want to expand on that? I mean, what do you see in reality of the value of something like this,
Yeah,
given
so
that the likelihood of prosecution is going to be pretty rare?
It's going to be hopefully extremely rare. I mean,
Hopefully
I think we have to hope, and I was very seized of the evidence you got from academic colleagues that were in the 4th of November, where I think that we would all ask the question, what events would have been prosecutable in the past associated with that, and there was very few. And that's great, because that effectively means there hasn't been something as sort of seismic. And would hope that in past this bill that we'd never have to use it, because it would be so severe. But just because we don't ever want to have to use something doesn't mean to say that we shouldn't have it, because the deterrent effect is important. The case has to be made that there's a level of harm to the environment that is not adequately provided for in existing legislation. So a new offence of ecocide needs to address the most extreme, willful and reckless cases of harm. And so the new offence shouldn't arrange the range of activity that's already covered by legislative provisions, but also shouldn't knock them out. A decision, it shouldn't be a case of, like, if we go for ecocide, does that mean we can't go for Section 30 under the Regulatory Reform Act? So that is something that I'm wrestling with in terms with my officials, as to how we can dovetail it into with the existing provisions. We need to ensure clarity about what the proposed bill intends to achieve, the purpose and nature of the new offence. The proposed new offence is not designed to address those lower levels of environmental damage, but we've already got existing law for really quite significant, I'm quoting from the actual law, significant events, including, and this is important as well, including damage that arises from permitted activities. And that's another area of the bill as set out in draft by Ms Lennon, that I think also has to dovetail better into the existing law, because permitted activities, I would suggest, have to be reflected in the bill as well.
I think other colleagues will want to come in on that. It's just where some of the kind of lines sit between existing regime and current or future regime. Can I just then finally ask you about alignment with EU law, in particular the Environmental Crime Directive, and just whether the government had considered in the past kind of using the keeping pace power to align more closely, because on the face of it, this bill does bring closer alignment with the EU, but there might have been other options there that the government could have considered outside of this bill to bring the law in line with that important EU directive, particularly in terms of sentencing.
So we're already considering the revised EU Environmental Crime Directive under our alignment policies. Section 40 offence already goes beyond what the previous version of the directive required. But this bill, if it's passed, will be a stronger response to the directive's provisions for qualified offences. We have to recognise that what Ms Lennon is proposing would make us one of the first countries to have ecocide in law. So we would be going further. But how many other countries in the EU and across the world are considering that? There is a considerable campaign and movement decides. So we want to maintain our policy alignment wherever possible. The one aspect of the directive is that it requires the introduction of higher potential punishments for qualified offences covering a wide range of existing offences and an enhanced level for punishment for more serious environmental damage. So obviously we've got the existing law, again, a very, very high bar in terms of section 40. But Ms Lennon is proposing an even higher bar for the most serious ecocide as defined events as well. So penalties proposed in the ecocide bill, for example, go further than what's... So actually, we're already looking at alignment, but this bill, and I think we already are aligned broadly, but this bill would bring us beyond alignment.
Okay.
And that's no bad thing.
Okay, thank
They
you.
could go further.
Thank you.
Thanks, Mark. I think the Deputy Convener wants to come in with a few points. Michael.
Thanks. Good morning. I just in response to Mark Rusco, I just wanted Cabinet Secretary to pick up on a couple of points, because obviously any form of criminal legislation of this nature, the lead agency who will be responsible for its implementation will obviously be our Crown Office and Procurator Fiscal Service in seeking to pursue a prosecution. In their evidence to the committee, they said that they struggled to identify, and I quote from them, they struggled to identify a scenario where the existing legislative framework would not be sufficient. And this is out with the quote, most notably given the availability of the Section 40 RRR offence. However, they go on to say they recognise that if you want to find a gap, I think that the gap relates to massive instance where you'd be limited in sentencing, because the sentencing is limited to 5 years under the RRR.
Yes.
And we then got evidence from the legal expert Murdo MacLeod KC, who said that if Parliament thought the sentences were lagging behind what it should be to mark the gravity of an offence, that 5 years penalty should be amended, which you would obviously amend through the RRA. Yeah. In your earlier response, you mentioned that if the Crown Office were to try to pursue a prosecution under this legislation if it was implemented, if they weren't successful in doing that, they could then actually use the RRA. My understanding is that from the evidence that we received from the Crown Office, they actually said that because of the thresholds with this bill, they would actually be much more likely to prosecute under RRA to secure a prosecution, which does beg the question, given their expertise and the need to implement this legislation. What is the purpose of actually having a standalone offence then?
And I think you raised some important points, and you've gone through some of the things that we were discussing as Ms Lennon brought the bill. What would be the purpose of a standalone offence for the most severe incidences? I think there's also a general point about the sentences associated with the RRA as well, and I think that's maybe something that also needs to get looked at, because if they are lagging behind, and if the bar of ecocide rightly is very, very high, if it's not provable at that stage, and then the RRA is the vehicle in which to secure a prosecution for a significant event, but the sentence, the existing law doesn't give the leeway for the judge to have penalties associated with it that are commensurate with the gravity of the offence. That is something, and that's, I think, probably one of the things that I was initially keen to speak to Ms Lennon. Well, could we reform the RRA to include these type of offences and to make it, you know, of the penalties more commensurate with the... So I think that going forward, regardless of if this bill goes through, I think that's something that we do need to look at, because what we don't want is prosecution under the RRA is looking like, well, you know, a much lesser penalty associated with it, where you've maybe got an event or a series of events that have caused huge environmental damage, massive cost associated with it, long-term damage, and that's not reflected in the sentence. So I think you make a very good point.
Yeah, but of course, we could just amend the RRA to lift up the sentencing powers to 20 years. Why would we not do that?
Well, I mean, that is a good question. Again, it's one that I wrestle with. It's one that I spoke to Miss Lennon about. It was an offer, I suppose, that we did make, that we could have worked on something like that. I think things are moving quite fast in terms of the campaign internationally to actually put ecocide into law. What I didn't want to do is, I suppose, have any notion that we were lagging behind when other countries were perhaps putting ecocide into law. So I obviously worked with, spoke to Miss Lennon about whether or not it was necessary to go ahead with a bespoke bill. I think my reason for supporting it was that it does provide additionality in terms of the bar. It is a much higher bar than the RRA, but the RRA is still there. And I wanted to make sure, and I still want to make sure, that if something isn't prosecutable or provable under ecocide, that wouldn't prevent RRA from being considered. Yeah,
and no, I understand that point. You mentioned earlier on as well is that a bespoke bill could actually have a deterrence effect. I'm always interested in the idea that new criminal law acts as a deterrence. What's the evidence base to support the argument that a bespoke bill delivers deterrence?
I wonder, I mean, I'm not avoiding the question, if that's so much a question for me as a question for the person that's bringing forward the bill, because obviously Miss Lennon sees that, that there is a reason for bringing forward the bill. I also would point to, not so much my view, but the views of again, I think it was Professor Hendry that made the point in the 4th of November, that she thought there was merit in a bespoke bill of this type, actually providing a deterrent in terms of there being a higher penalties associated with ecocide. The ecocide is something that would be discussed out there in terms of Scotland going first, I suppose, in ecocide. I can't find the exact quote that she had, but obviously it's in the official report.
I have it here for you, if it's helpful. Yeah, she said it's difficult to have an evidence base for a deterrence effect, but instead of changing Section 40 with its high penalties, the passage of a specific bill would probably attract some regulatory attention, press attention and corporate attention, which might strengthen the potential for a deterrence effect. So beyond the PR aspects of it, I think it'd be fair to say there wasn't much evidence, which I think is probably, from my understanding of deterrence effect of criminal legislation, evidence broadly says that when folk are committing criminal offences, the last thing they're thinking about is the actual criminal penalty that will be applied to them.
Yeah, I think that's a fair point, and I think that again, when Miss Lennon came to us about an bespoke ecocide bill, these were points that we did put to her. We felt that Section 40, the Regulatory Reform Act, already provided provision, and of course we also have to reflect on how often or not it's been used. Thankfully, and I think there was a difference of opinion of whether, there were certain things that it should have been used for in some of your evidence gathering. But we thought that, on balance, reforming that would not have put the spotlight on the offence of ecocide in the same way that a bespoke bill was. So obviously I'm keen to see what Miss Lennon says to your question. As it stands, I'm keen to support it in the passage to stage 2. I have things that I would like to amend in it, so that it, is compatible with the HCR, so that it is given additionality. I think that's very important, and I understand your general point in that regard.
Okay, thanks.
Michael, we'll move to the next questions that come from Bob.
The same way that I think you've been as a government, and that is in relation to standalone offence and reform the Regulatory Reform Act. Can I just ask briefly, if the Regulatory Reform Act was to be reformed and additional sentencing powers up to 20 years, there'd have to be criteria for that, convener, there'd have to be guidance in relation to that, and the word ecocide could be used on the face of any legislation here that reformed the Regulatory Reform Act. So, in effect, I suppose my question is, can we create provisions for an ecocide offence by reforming the Regulatory Reform Act? Does it have to be an either-or?
Yeah, we could do both. I mean, we could have a standalone bill, as Monica Lennon's proposing, or we could reform the existing Act.
But I suppose just checking, we can still say that we've created an ecocide offence because we could put it on the face of the bill that amends it.
Can I bring Charles as to why he's here?
Of course.
Yeah, it's clearly more straightforward and visible to create a new offence with a new name, with a new bill. If you're amending an existing legislation, there's a limit to how far you can go in terms of, you could certainly create an enhanced level of offence for the existing offence. Whether you could then call that a different name would be a technical question for the drafting, but it would certainly be less visible than a full standalone bill.
Possible, but perhaps not visible, as maybe the member would like it to be. I suppose I just wanted to check that. So, in our wrestling in relation to the difference between the ecocide offence and the Regulatory Reform Act, we want to look at the definition of ecocide in relation to there being serious adverse effects that are either widespread or long-term. And our notes used the expression that's a bespoke definition. I think Cabinet Secretary used the expression bespoke as well in earlier comments. Cabinet Secretary, do you think that definition is necessary? Do you think it's appropriate to define severe harm in this way for the purpose of an ecocide offence?
So, the definition of ecocide has been developed for international law purposes, and it's been adapted to the domestic legal system. So I'm of the view that the definition of ecocide as drafted is workable. If members were to bring forward amendments on the definition of the offence, obviously I would give them my consideration, and obviously Ms Lennon is leading the bill, would have a view as well. The environmental harm definition in the bill is given, it's the same definition in the Regulatory Reform Act though. The definitions of significant and severe environmental harm, they both include serious adverse effects. So the new offence specifies that the harm must be either widespread or long-term. We have been discussing this as officials. We're not sure there's any benefit in seeking to add further conditions to the definition of serious environmental harm for proposed ecocide offence, because we think it would ultimately be up to the prosecutors and the courts to determine whether an offence has been committed of a seriousness to justify ecocide. And we don't know what hopefully none, but future events would fit the bar. But we need something that is able to cover the most serious and potentially unforeseen events.
I suppose the reason for asking the question, Cabinet Secretary, is to be clear that the Scottish Government thinks it's clear and distinct from the current law and the current legislation. I suppose that's what you want to check, that it's distinct and clear, that it's different from the current definitions.
I mean, environmental harm, keep on going back to that. The definition of the bill as written is the same definition as the Regulatory Reform Act. Okay. So that is a point that I think obviously members will speak to Ms Lennon about that.
Okay, of course, Cabinet Secretary. Can I have a look at how the bill applies some other definitions in relation to harm caused by course of conduct or consequential impact over time? I'm just wondering if you think that the bill is sufficiently clear on that. In earlier evidence sessions and we were talking about, you know, an organisation could believe they've got a clean bill of health because they're meeting all the regulatory requirements that are asked of them, they're inspected, they're looked at, and each year a clean bill of health, if you like, but then someone looks at that impact over a significant amount of time, and then you come in the gambit of a perhaps ecocide definition. So I'm just wondering whether you think that how the bill applies or intends to apply to harm caused over course of conduct or consequence over time is appropriate.
So whether the serious harm or the severe harm is caused over time or a one-off, it's the severity, it's the threshold for the harm that's, to my understanding of the bill, is the issue, not whether it's carried out over a period of time, whatever that time would be, or whether it's a one-off event, because it is the impact of whether it's a serious and long-term effect or whether it's a one-off that's the issue.
Okay, no, I appreciate that. And these are quite difficult matters to kind of navigate around. But I suppose the committee, or myself, is thinking about the environmental impact from 2024 to 2025 may be relatively minor, but the environmental impact from 1985 to 2025 might be quite significant and profound. So you can see on an incremental basis the impact doesn't look that significant.
And it would be up for the prosecution to prove that.
They also never ask a question that you don't know the answer to, Cabinet Secretary. We're going to do it anyway. How does the current legislation in relation to Section 40 of the Regulatory Reform Act, how does it deal with such matters? About that long-term impact? Does it have appropriate provisions in relation to that?
Charles, I mean, I don't know whether we've got, I mean, we've got no difference, because it's the actual extent of the harm that's the issue, I believe. I'll be corrected with my officials if I'm not right. It's the extent of the harm. It's the significance of the harm.
I mean, there is the key difference that the Section 40 offence has an explicit defence of carrying out a licensed activity, whereas the Ecocide Bill as introduced doesn't have that defence. So in your scenario, if the operator was carrying out a licensed activity and over time that built up to damage, it still would not be liable for a Section 40 offence because it's a licensed activity. Whereas this bill as introduced doesn't have that defence of licensed activity. The operate that, and that's the concern that I think the committee heard from the Fishermen's Federation and from the NFU Scotland, is that you cumulative effect of doing a perfectly legal licensed activity over time, and their concern was that ultimately could be seen to fall under the provisions of this bill as it's introduced.
Now, I know colleagues want to explore that in much more detail later on, so I won't explore it further, as tempting as to do, and I'll just ask my final question. A number of witnesses have suggested to the committee that an ecocide offence should explicitly cover omissions or failures to act, as well as acts itself, as with Section 40 of the RRA. Given a failure to act could also cause environmental harm. Does the Scottish Government have a view on that particular issue?
I've seen some of the evidence of people that wanted to have omission and failures to act. We don't believe that there is a case to expand the scope of the bill to cover omissions beyond the extent to which they're already covered, because the acts of omissions are already covered by the offence of ecocide as it's set out, we believe. So the offence is of causing severe environmental harm intentionally or recklessly. Harm can be caused by omission already. So we don't see that there's a case for further inclusion of omissions.
Okay, so you don't believe it needs to be any more explicit on the face of the bill than it currently is. Okay, thank you. Thank you.
Mark, I think you wanted to follow up on that, did you?
I just wanted to go back to some of the definitions here and just ask you whether the government would be looking to make any amendments should the bill get to stage 2. So specifically on long term, I think the bill defines that as 12 months. I think we had some evidence that it's really hard to see how an ecosystem could recover within 12 months. So, yeah, there was some questioning, I think, around that definition in the bill. So I don't think there's any aspects around the definition of ecocide where
I mean,
you have
I'd be
a firm
happy
view at
to.
this time to come back and say, well,
Yeah.
actually, no, we think there's a different figure we'd want to put on that, or a different way of framing some of
whether
these things.
a figure at all is appropriate, because
Okay.
I mean, I think you've just pointed to some of the difficulties around this. We don't know what the nature of the offence is. We don't know how long it's going to, take to recover from a particular event and how you can actually measure it. So I think it's a particular difficulty. Obviously, members will have that idea, maybe have ideas for amendments at stage 2 or questions for Ms Lennon. But I think you've pointed out a difficulty. For us, it's about the impact and the severity, not the duration.
Mm-hmm. Okay, thanks.
The next questions come from Sarah. Over to you.
Thanks, Convener. I want to ask about vicarious liability and to focus in particular in relation to companies. And if you look at the bill, the threshold for liability in the bill requires intent or recklessness for the main offence. And some of the evidence we got suggested that that's too high a threshold because of the difficulty of proving intent or recklessness, and because in reality such offences, especially when committed by big companies, might be more likely to result from negligence or poor governance, thinking both about work by an actual company or by a subcontracted company. So wondering what the Scottish Government's view is on the appropriate threshold of liability for the main offence in the bill. Do you think a lower threshold would be appropriate?
So this comes back to the dovetailing in with existing legislation, because ecocide is meant to have a high threshold. So if I'm understanding Sarah Boyack's question correctly, you've just proposed bringing the threshold for the offence down lower than actual ecocide, as defined. Is that the question you're putting to me?
It's just a concern that if ecocide has been actually delivered, but it's really hard to actually hold anyone to account to it because of the threshold.
So vicarious liability in terms of actually holding the organisation responsible, I think, is something that's already got precedent in Scots law. And I think it would be entirely appropriate, that I was just doing what I was told to do by my, is first of all, means that a tremendous penalty could be put on a person, whereas the organisation is left to continue on without any penalty at all. So I think it's entirely appropriate that there are provisions in the bill for vicarious liability.
Yeah, well, I was focusing on the actual organisation that would be held to account and accountability.
So the seriousness of the crime puts it above negligence. So again, if it's ecocide, it's not negligent, it's willful. And I think it comes back to the definition in the bill that it has to be willful, reckless. That's what has to be proved. And willful on the part of an organisation would suggest telling an employee to do something that is causing severe harm to the environment. So, but that's the thing that has to be proved. Obviously, it was willful and reckless.
Okay, yeah,
But reducing the threshold for what ecocide is, I think, is problematic because, as I've said, and the many that I've said, we've already got law that we deal with that. That includes vicarious liability,
Yes.
as it stands. Yes. Yeah.
Okay, and if we dig into the issue about, we've been talking about the Section 40 offence in the RRA. we'd prefer this legislation rather than amending the RRA section 40
I don't prefer either. As I've said, the vehicle to amend the existing legislation was there, and it could be done. But when Miss Lennon presented the bill and the evidence associated and the consultation responses and put forward the bill, I thought this is a vehicle in which it could have the same effect and potentially shine a light on ecocide as an actual offence. Now, not everyone will agree with that, but I was prepared to see what the committee thought and prepared to see what those that gave evidence and whether that we did. But again, I come back to this thing, has to provide additionality to the existing law. And that's also, I go back to that previous comment that I made, that I would want to, if it gets to stage 2, ensure that just because it isn't provable in court, the threshold of ecocide, that they also could be prosecuted for the offence under Section 30 of the RRA.
Okay, thank you.
Thank you, Sarah. Douglas, I think you've got some questions.
Yeah, I have. I'm just going to pick up, if I can just pick up on that last point, Cabinet Secretary. So, were you suggesting there that if ecocide couldn't be proved in court, then they could then go to RRA to do a prosecution that way? Is that what you were suggesting?
So I'm suggesting there may be ways to address the concern that people have put that, you know, ecocide's got so high a bar. A formal connection could be made between the two offences, such as an alternative conviction provision. And it's worthy, I mean, I'm just putting it out there, it's worthy of further consideration. I haven't decided what we would put forward at stage 2 at the moment, but it's something that could be. So an alternative conviction provision provides for courts and juries to consider a specified lesser offence if they're not convinced that a conviction is merited under a greater offence. I'm not making that up. That is actually a provision that could be made. So there could be merit in the bill establishing the Section 40 offence as an alternative conviction to the new ecocide offence. I'm giving consideration to that because, as members have mentioned this as a concern, it already was a concern for us in government. Ecocide has to provide additionality, but with that additionality to law and that very, very high threshold and bar, we could provide in stage 2 an amendment that could have this formal connection between the two offences. I would like to see other amendments to the ecocide bill to make it more in line with the RRA, because there are areas in which it is not in line with the RRA, and I've mentioned a few of them in the last half an hour.
Okay, so I'm just trying to think how it works. So the prosecution service might be going down the ecocide route, maybe going down, you know, take it to court, maybe during that trial, then they think, well, we're not going to get that that high bar of ecocide. We can maybe then go switch instead to Section 40. Is that what you're saying? And not found not guilty and then being able to be retried under the Section 40?
So I'm giving consideration to it. I won't use the phraseology like switching that there's long was, but I've set out, and I've been very careful in how I've set it out, because we have not arrived at a decision as to what, you know, if it's stage 2, it will be at stage 2. And of course, other members might be wanting to do similar, and we could work with them on that. But that alternative conviction provision provides for courts and juries to consider a specified lesser offence at the same time as ecocide. So presumably the verdict could be given, we can't prosecute on ecocide, but they are found guilty of the Section 40 of the RRA.
Sorry, if I don't normally do this, and I apologise, Douglas, but I'm slightly confused here, because what we heard in the evidence, or I thought I heard in the evidence, was that if there were two offences, one on a lower shelf and one on a higher shelf, that you'd always go for the lower shelf first because there's more chance of getting a conviction.
Can I bring in the lawyer?
Yes, and I'm delighted if you want to argue with the Crown Office. I think it'd be an interesting debate.
But bear in mind, convener, we are just airing this.
Yeah.
You know, at the moment we haven't decided.
No, and that's why I'm trying to get.
And we are just airing it. So
Yes.
over to
David.
Yes, that's right. It is something we're just considering. But so what you have to bear in mind is you've got higher penalties for this ecocide offence. So it might be that the gravity of the crime justifies these higher penalties. So you might have the Crown Office charging someone with ecocide. And obviously, with ecocide, you have to prove mens rea, intent or recklessness, whereas you don't have to do that with the Section 40 offence. But the penalties there justify charging for ecocide. But it might become apparent through a trial that...
Sorry.
So,
Sorry, I apologise. I don't know why that happens, but apparently if my phone is on and there's an alarm at home, which is... I'm just going to stop this.
at least it's not
Because of the... I'm just going to explain that. It overrides everything because it's a security alarm put in by the police at home. So I apologise profusely for that. So I don't know why it's gone off. I hope my wife's fine. I guess if she's not, she's called the police. So I apologise profusely to the committee. David, back to you. I'm embarrassed.
No, that's fine. Yes, so where was I? So yes, you would.
Sorry, apologies
No,
again
that's
if you
okay,
want to
that's
gather
okay.
your thoughts on it.
So you would yes. So it might become apparent halfway through a trial that there's not enough evidence there to convict for ecocide, and then you could switch. But there seems to be enough evidence for the Section 40 offence. If it was libelled on the same indictment, you could switch to the Section 40 offence, or the jury could convict for the Section 40 offence. So that would be the provision that you would have, a possible provision that you would have this if you couldn't, if the jury couldn't convict for the ecocide offence because you didn't meet the thresholds, then the jury could convict for the lesser Section 40 offence. So that would be how a provision like that would work. So there'd be the jury could automatically consider the lesser Section 40 offence. So you can at the moment. So the prosecution could, at the beginning of a trial, perhaps libel two charges, ecocide or Section 40. But what an automatic alternative conviction provision would do would allow a jury to consider the lesser charge at the end of a trial if it hasn't been libelled at the beginning of the trial. So that's what a provision like that would allow the jury to do, essentially allow the jury to convict for the lesser charge. If they think the ecocide offence hasn't been made out during the trial. So that's how that kind of provision would operate. And there are examples of that provision in other pieces of criminal legislation. So that's how a kind of alternative conviction provision would work. That's all that's in that.
Cabinet Secretary, I think Charles might be wanting to come in, but it's up to you whether you let him, of course.
Yes, of course.
If I may, Chris Craig, just to clarify, we're not in any way disagreeing with the Crown Office evidence they presented. We're suggesting a possible way that the bill could be amended to deal with the problem they identified.
And we are just suggesting it. We don't know whether or not we'll go down that route or whether someone else will go down that route, but we thought it was worthwhile airing it.
Okay, Douglas, I'm going to hand back to you, and I'm going to ask Michael just to convene the meeting while I just step out to make sure my wife's all right. I think she'll be cross if I don't. So, if you'll excuse me, and
okay.
Douglas.
Thank you, Convener. Cabinet Secretary, so the threshold for liability for senior responsible officials of an organisation is consent or connivance. And the committee has heard views that consent, connivance or neglect would be more in keeping with comparable provisions. Does the government have a view on this? Should neglect be added?
So if negligence was mentioned there, am I right?
No, consent or connivance.
Consent.
Yeah, and then adding, I was suggesting adding neglect in
Right. It goes above negligence, doesn't it? I mean, that's negligence. I think we come back to some of the terminology. Ecocide means unlawful or wanton acts committed with knowledge that there is a substantial likelihood of severe and either widespread or long-term damage. That's the definition that is set out from the expert panel in the definition of ecocide. So, wanton means with reckless disregard for damage, clearly in excessive in relation to social and economic benefits anticipated. Severe means damage that involves very serious adverse changes. I don't know how negligence fits into there. Again, I think it would be how would you prove that negligence was wanton? I think that's the issue here. Wanton, reckless. Negligence, I suppose, can be wanton and regular, but it suggests a knowledge of what you're doing. Negligence, does that suggest a knowledge of what you're doing is causing harm?
I think probably negligence, I would say, was probably maybe not knowing what you're doing, and that's a problem.
It's about proving. I mean, again, can I bring the lawyer in on this because?
Yeah. So I think negligence. And negligence. I think the way this offence is framed is that it's to be aimed at serious harm committed with intent or with a kind of reckless disregard to the consequences of your actions. So I think the attributing liability to an individual that has to be framed in light of the kind of intent and recklessness. So negligence doesn't quite cut it. You have to be more than negligent to commit this crime. If you want to commit the Section 1 offence, you have to be more than negligent. And so having omitting negligence from the individual liability provision fits with the purpose of the offence.
Okay. Next question was, so the committee has also heard concerns that defining responsible individuals in relation to the corresponding type of organisation could leave scope for non-senior staff to be prosecuted, i.e. middle managers. Do you think that's right, or?
No, I mean, I think vicarious liability is important in everything for the reasons that I set out to say the Boy Act. So I think there has to be provision in there to make sure that what the scenario that you've just outlined can't happen, where effectively you've got a fall guy, a junior member of an organisation being prosecuted for something that's actually been the intent of the organisation. There has to be vicarious liability provision in there.
Okay.
As well.
And in terms of vicarious liability, what's your view on in terms of contractors for maybe a main company doing work, or for example?
Well, again, they're working under the direction of the organisation, so I wouldn't see any difference. Again, David has got the letter of the law here, but you could have an individual who's just contracted in, but they're actually given a job to do something that has caused this willful, wanton. Yeah, it covers it. So vicarious. If we point to the section. Acting as the employee or agent of another is already provided for in the draft.
But I guess if that contractor, contracting company, was maybe, I'm going to say negligent, but we'll stay away from negligent. Maybe acting in you weren't following proper procedures or anything else, and then causing an incident. Would it be? Where would the buck stop? That's what I'm trying to.
Well, I think you'd have to prove that. You'd have to prove that they went rogue, I suppose, is what you're saying.
Yeah.
You'd have to prove the fact that it was like a contractor that was doing it off their own back without the instruction of the contracting company. Then that's something that it could be provable as to who's actually responsible for the offence.
So you think if they're following proper process, then it is the contracting company that.
Well, you say proper if they're following the direction of the contracting company. Then,
so then that would rest with the contracting company. Yeah. Maybe if they were going a bit rogue, then it would be the contractor.
Yeah.
That do that.
Say a contractor comes in and they cut corners without the express knowledge or direction of the of the contracting organisation, then, you know, it won't just be Ecoside that they're taken to court first,
Yeah.
but they're probably going to be taken to court by the company that's contracted them.
And do you
as
think
well.
that's explicit enough in the bill that people understand that, or do you think
I
there needs
think,
to be
I mean,
changes?
it's under the vicarious liability, so commits the offence of ecocide acting as the employee or agent of another.
You think it's covered?
We feel satisfied that that's covered in the bill.
Okay. Last question I had. Do you think there's any unintended consequences around the bill? And I'm thinking things like maybe where a company's headquartered, for example. Do you think there's any dangers around maybe HQs moving away from Scotland because there's an ecocide bill, ecocide law in place?
God, can I just, a personal opinion, anyone that doesn't come and work in Scotland because we've got an offence of ecocide suggests to me that, you know, I mean, what would that say about the company? Yeah, we want all companies to be acting responsibly. You know, if environmental law is there to prevent serious harm to the environment, whether it's in the RRA or whether it's an ecocide bill, what would that say about a company that they wouldn't come and do business somewhere because there's an ecocide law?
So you don't think? So, because I'm just trying to think, you know, if we take, obviously, if there's not an ecocide law in the rest of the United Kingdom, I guess companies may feel there's maybe an added risk coming to Scotland, or do you not feel that would be the case?
It's such a high bar. I mean, it's such a high bar. Ecocide is, I mean, again, that's the big debate that we're having, whether or not it is sufficiently additional to what's already there in Scotland is already a discussion that we're having. I would be very wary of a company that wouldn't come and work in Scotland because we had an ecocide bill. That... Yeah.
Any other unintended consequences?
Well, there are a couple that I would like to. I mean, again, I want to go back to the permitted activities. I think it's important that we have provision for that in this bill. If it's not put in by anyone else in stage 2, or in fact, I'll probably be putting something in to make sure that we allow for permitted opinion. I think that as it stands, the burden of proof being on the defence isn't in line with ECHR. So again, that's unintended consequences. I certainly don't think that anyone meant that to be the case, but that's something that I would want to rectify at stage 2, or I would suggest that anyone else seeks to rectify in stage 2, because I think there are serious deficiencies in the bill as it's been laid. I'm just having a wee look here about yeah, I think I'll leave it there, because I've actually set out in my response to Ms Lennon in our memorandum some of the areas in which I think there are unintended consequences with the drafting of the bill as it's current, but those are the main ones in my mind.
Okay, thank you, Convener.
Thank you, Douglas. Mark, I think you've got a follow-up, and then I'm going to come to the Deputy Convener who's got a couple of questions, and then I'll come to you, Kevin.
Just reflecting on some of the conversation this morning, can I be devil's advocate and say, if there was, say, an 8-year prison sentence penalty available to the courts under the RRA, and a case came forward and it was shown that somebody had, or a company had, you know, carried out an action which led to really severe, really, you know, wanton environmental damage, there was clear intent, it was clearly willful, would that effectively be ecocide?
Yeah,
because there isn't like I mean, I guess what we've had in evidence is there's lots of ways to implement ecocide. And Monica Len's brought forward, you know, a very clear proposal. But I'm just thinking around the other options, going back to the RRA again. Would, for all intended purposes, would that not be an ecocide conviction if someone was imprisoned, responsible officer was imprisoned for 8 years, there was clear willful intent, and they were convicted under the RRA?
No, they would be prosecuted under the RRA. So an ecocide's not mentioned in the RRA.
But would that not
But obviously there's
ecocide?
significant environmental harm. So whether you could actually officially say they have been accused and prosecuted of ecocide will be no.
Okay.
Because if they were prosecuted under ecocide, if Ms Lennon's bill passes, there will be an offence of ecocide.
But couldn't the courts make a determination? So if there was like really severe environmental impact, if there was a clear intent and the courts had to make a decision between a 5-year penalty or an 8-year penalty, would the 8-year penalty not actually feel more like an ecocide offence?
Again, can I bring David in, because he's the lawyer here?
So are you talking about amending Section 40 of the RRA to
I'm not
include a higher...
proposing anything at the moment.
Okay.
I'm just exploring the territory.
Yeah.
If that provision was available under the RRA, would the courts not be able to consider under an 8-year offence whether that environmental impact was severe, whether there'd been clear intent? I'm just exploring from your perspective where you see the argument is for the standalone offence.
Yeah, I suppose our position is that this covers serious conduct that requires intent or recklessness, and that's required because of the severity of the punishment that you're going to receive. So if you're going to get maybe a 20-year prison sentence, then it's right that you've got quite a high threshold for the commission of this offence, because you're going to go to jail for a long time. But if you're being... The prosecution would have to work out what they were charging you with before a trial starts. If you're charged with a Section 40 offence, then there would be a limit on the prison sentence you were getting of 5 years if the Section 40 offence is being libelled. So you'd have to be being prosecuted for the ecocide offence for there to be the option of getting a prison sentence of over 5 years, perhaps up to 20 years. So you'd have to be getting tried for that offence before the judge could consider what penalty you're getting.
Yeah, but the point I'm making is if there was an 8-year prison sentence penalty available under RRA,
Right.
would that lead to an equivalent ecocide provision, or are we always thinking about something quite distinct by having ecocide at the kind of apex of the legal system, or is it actually possible to create an ecocide offence within the RRA is the territory I'm interested in your view on?
Yeah, I think that point was covered earlier. I think it is possible to amend Section 40 to get something equivalent to ecocide. I suppose the benefit of this offence is that it is more public, draws people's attention to the matter, and covers serious conduct with an appropriate kind of serious penalty attached to it. So yes.
But that's also why we want to link the two.
Okay, I understand.
We may want to link the two.
Yeah.
We're considering it.
Okay, Michael, I think you've got a brief question.
Thanks, Convener. Can I turn to the defence provisions within the bill in Section 2? In your policy memorandum, you've suggested that 2.3 within the defence provisions is incompatible with ECHR on the basis that it requires the accused to establish a defence of necessity on the balance of probabilities, whereas ECHR operates on the basis of a presumption of innocence. Can you elaborate further on what the government's view is? Do you believe the bill as drafted is incompatible with ECHR and existing case law?
Yeah. So Section 2, Part 3 of the bill departs from the common position by placing the burden of proving the defence of necessity on an accused person, and that was effectively reversing the burden of proof. So careful consideration needs to be given whether that reverse burden is compatible with the convention right. We don't think it is, and I think that is a flaw in the drafting of the bill. So, you're absolutely right. Article 6 of the European Convention on Human Rights, presumption of innocence is an aspect of a person's right to a fair trial. This overturns that. It reverses that. So we feel quite strongly about this, and should it get to stage 2, we would be looking to change that.
Okay, can I just maybe just push a bit further on that then? Can I just clarify, is that on the basis of existing case law rather than just an interpretation of ECHR?
Well, yeah, again, I could bring the lawyer into it, but this is a convention that Scots law adheres to, the presumption of innocence. You have to, it's up to the prosecution to prove the guilt of a person, not the other way round. I can bring in David.
It's unusual to reverse the burden and have the accused person establish that they have the defence. Usually an accused person doesn't have to prove anything in a trial. It's all up for the prosecution to prove their case beyond reasonable doubt. Sometimes the burden is reversed, and there are some instances of it, but there's no rule of thumb as to whether a reverse burden is compatible with Article 6 or not. You have to consider the facts and circumstances of each case in which it appears to consider whether it's compatible with the right to a fair trial. And I think there are a few issues with this reverse burden. So the problem is not that that they've got this defence. I think the problem is that there's this legal standard of having to prove your defence on a balance of probability. So the accused person has to prove that it's more likely than not that they had this defence. And when you're considering whether the reverse burden is compatible with Article 6, you have to understand whether it's proportionate or not. You have to work out, is this a proportionate measure to the aim you're trying to achieve? And we don't think it's proportionate for a few reasons. The main issue is the way this defence is structured. So you have to prove that there was a greater harm that you were trying to prevent, and you also have to prove that your action was necessary and reasonable. And we think that would allow a jury to convict someone, even if they had some reasonable doubt about the guilt of a person in light of this defence. So if for example, the accused person managed to prove that there was a greater harm that they needed to avoid, there was more likely than not a greater harm that they had to avoid, but then they failed trying to prove that it was necessary and reasonable, their actions were necessary and reasonable to a standard on the balance of probabilities, then that, our view is that the jury would have a reasonable doubt about a person's guilt here in light of they've been able to partially establish this defence of necessity on a balance of probabilities, but not the rest of it. And the jury wouldn't be able to take that into account, and they would have to convict if the prosecution had proved the main elements of the Section 1 offence. So there's the structure of the defence risks unfairness on the accused. And also there are a couple of other things. It's not... Sometimes you have a reverse burden where it would be easier for the accused to prove their defence than for the prosecution, or there would be an unworkable burden on the prosecution to disprove any defence. But in this case, we don't think the prosecution would have too difficult a task at disproving this defence. And also, the case law on this talks about... There's a kind of theme whereby the more serious the offence, the more social stigma attached to an offence, the more severe the punishment attached to an offence, that actually goes against a reverse burden. So you have to have, you have to be able to really justify a reverse burden where there are really severe consequences for the accused if they're convicted of this offence. So you sometimes see reverse burdens in relation to kind of so-called regulatory offences, but this offence is a very serious offence with a very serious punishment. So to have a reverse burden here, a legal burden where you have to prove on a balance of probability that you've got the defence, is not appropriate for such a serious offence. Because you could have someone being convicted where there's doubt about their guilt, and then they get sentenced to 20 years in prison. So that's why we don't think this is appropriate, and that's why we don't think it's a proportionate kind of measure in relation to this offence. You could consider replacing it with an evidential burden, which is not a legal burden, and an evidential burden would require an accused person to lead at least some evidence that they've got the defence, but they don't need to reach this kind of legal test. So that's a possibility.
Thank you.
Thank you. Kevin.
Thank you, Convener, and good morning. You said earlier on that the bill, as proposed, has serious deficiencies, Cabinet Secretary, and a number of the witnesses that we have heard are of the same opinion. Section 40 has a defence for licence permitted and consented activities. This bill has no defence for that. That has been a concern to industries such as the farming sector, fishing, renewables. You indicated, I think, that the government was looking to amend that aspect of the bill. Am I right in thinking that?
Yeah.
And how does the government intend to proceed in that manner?
Yeah, so you're absolutely right, Mr. Stewart. I have we have, even ahead of the submissions. There's been submissions that have been made by local authorities and obviously permitting authorities. I favoured the introduction of an amendment of defence of acting under permit or other authorisation, as exists already in the offence at Section 40 of the Regulatory Reform Act. Again, it makes it compatible with that, but it also provides that defence. You're right, NFU have mentioned it, Scottish Fishermen's Federation, but also a lot of the local authorities have mentioned it as well.
I'll maybe come to local authorities in a second, Cabinet
So
Secretary.
it's important that we need to recognise that a defence of carrying out a permitted activity is not a licence to commit ecocide, but acting out with the terms of the authority could expose someone to prosecution for ecocide. So if it's permitted activity, then there's already provisions in the application for the permit and the decision to give the permit that have to be met by a person. So if someone acts out with the permit, they're acting out with the permit. Yeah, they could be willfully committing severe environmental damage.
If they're conforming with the permit,
that has to
with
be
the
a defence.
consent, with the licence,
yes.
you intend to put forward amendments to ensure that there is a defence there, like in Section 40.
Yeah.
I'm very keen to go over how much work the government has done in terms of unintended consequences. And again, I'd like to go over the fact that there is no defence in the bill at this moment, apparently, to prevent a regulator or a consenting body from being held liable for ecocide. I would imagine that you are going to bring forward amendments to change that, and if you were not, then that's certainly something I would consider doing. Over the past few weeks at my behest, the committee has written to local authorities. We have a number of responses back, which are somewhat concerning, and in some cases I think very concerning. Fife, for example, very experienced head of planning, Pam Ewing, says we support the intent of the bill, but strongly urge that explicit defences for consented licensed activities are included, that enforcement responsibility remains with specialist agencies and not local authorities, that definitions and thresholds are clarified and aligned with existing legislation, and that adequate resources and guidance are provided before implementation. They go on to say that without these changes, the bill risks creating legal uncertainty, unrealistic expectations and significant operational and financial burdens on local authorities. Renfrewshire Council has also responded and they talk about the possibility of criminal prosecution influencing the approach of the planning authority and put and that could put the plan-led system at risk. They go on to say that if some of these impacts are not dealt with, officers may be more inclined to decline to use delegated authority where there's the fear of a future criminal charge. They say that elected members on boards and committees may be more inclined to refuse applications. And they go further by saying that elected members may not be willing to serve on planning boards or committees for fear of being involved in any decision which may later be the subject to criminal charge. That could lead to a huge amount of bureaucratic clog in the planning system. It could lead to situations where huge amounts of, in some cases, quite small applications landing on the desk of the planning minister, for example, who, again, may well think to themselves, what do I do here? Is there the chance of me facing prosecution at a later date? Now, I would imagine that you are going to amend aspects of this in terms of the prevention of a regulator or consenting body being held liable for ecocide. But have you looked at this in enough depth to be confident that we could deal with this in amendments which, you know, would have to be brought quite quickly if this bill proceeds any further in what is a very short period of a parliamentary term?
So,
left.
as I said, I was ready. We were already going to bring forward amendment of defensive action under permit, but obviously we got the letters that you've been reading from last night, and obviously we're going to look at them thoroughly, because and I'll be happy to work with any member that thinks we can put amendments in the bill that would protect against the scenarios that Mr Stewart's just outlined as well. But obviously, we are taking the submissions from the local authorities that we got I got them last night, and we're looking at that in case there are any other unintended consequences. So, happy to work with any members to sort of test their amendments on this.
But what I'm getting at, Cabinet Secretary, is I understand that you're willing to cooperate in all of this, and that's grand. But you know, we only received, or I've only managed to read through this yesterday. I think they only came yesterday. There are a huge amount of questions in here. Questions which I had have been exacerbated by the responses that we have got back from local authorities alone. That doesn't include some of the other public bodies who will be taking decisions.
Yes.
What I'm asking is, I understand that you will be looking at amendments, we will be looking at amendments, but is there a time left in this parliamentary term to go through this in the amount of depth that's required to come up with the right amendments to get rid of all of the possible unintended consequences? Now, I recognise that some people want to get this bill through, but we've heard today that a lot of that is about the publicity, the visibility, and to make ecocide more public, right? I get that. I'm not averse to that. But what I want to see is legislation that actually works and does not have huge unintended consequences, which could, for example, clog up our planning system and cause great grief. So, do you think we have the time to do all of this?
Do I think you have the time? I don't know when stage 2 is going to be. So is that not the convener that decides that? Do we think we have time to deal with all unintended consequences? I don't know if I can answer that. It's not in my.
I think the Bureau decides with the advice from the committee.
It's not up to me to decide that. I'll be here at stage 2 no matter what with all my amendments, and I'll be working with any members that feel that they want to work with me on any amendments to deal with the unintended consequences.
Can I ask you then, Cabinet Secretary, have you had any discussion with the Planning Minister, and I suspect not, given that you only got this yesterday, around about the implications to the planning system if this bill
that's
were to
something that
go
I'll be
through
doing.
unamended,
Yeah.
or if it went through without the right amendments to get this right?
As I say, we already wanted to put a defence of acting under permit, and we also wanted to make sure that any of the regulatory bodies were protected here when they were working under licence or permit. But you make a very good point. The fact that we've had the volume and comprehensive nature of these responses is something that we will be looking at, and of course the Planning Minister will have to have a view.
I understand that we received some more correspondence this morning, which I've not yet seen, and I think more will come in. And I think that this is to be very seriously scrutinised to get rid of any unintended consequences. Can I ask you, and you gave some indications earlier, do you think there are any other unintended consequences that we have not discussed this morning that need to be dealt with by amendment? And do you think that in order for us to get this right, that if this proceeds, then we should be looking also to amend aspects of Section 40 of the Regulatory Reform Act at the same time?
So the committee will get a copy of our memorandum, which outlines our main concerns and where we would like to see it amended at stage 2. Of course, if there's anything in the period between now and stage 2 that we become aware of that's an additional unintended consequence, maybe as a result of some of the evidence coming in, the submissions coming in, then we would want to address that as well.
Okay, thank you. Cabinet Secretary, thank you.
I think it would probably, in fairness, just to back up what Kevin has just said, I think we got a further response at 8:48 this morning, just before we went into committee. But I would also say, in answer to your question, is the Cabinet Secretary knows fine well that we also have other business that we've got to deal with in the committee before the end of this Parliament, including the climate change plan, and you're driving that forward. So there are incredible pressures, and it would be unfair of me as convener to not say that time is of the essence when it comes to concern.
This is not my bill. I'm giving evidence on someone else's bill.
I know, but I just wanted to put on the record that this is the, and confirm what Mr. Stewart said, that this isn't the only thing that we're dealing with. Now, I've got two short questions, one from Sarah and then one from Mark.
Is this financial costs?
Yes, yeah.
Yep, good. I just want to flag the fact that different organisations have flagged the issue of costs of implementing the bill. SEPA raised concerns about the financial memorandum underestimating the cost that SEPA might have to bear. And there was also Nature Scott questioned whether they would actually need enforcement powers extended to them so that they could work with SEPA, potentially and related to protected sites or ecosystems. And then there's also evidence we got from West Lothian Council that they lack resources. And they were talking about monitoring issues, breaches of planning conditions, if local authority is the first responder in relation to a local event. So I was wondering if you have any comments about the need to make sure that there's further investment in public sector organisations so that they could actually implement the legislation.
So they can implement the legislation, or so that they can respond to environmental events that...
Leading on investigating an ecocide event, SEPA's questioning the cost in the financial memorandum, and other organisations like Nature Scott have got key environmental protection roles. So it's that issue in Section 9 about expanding enforcement powers. And do we need to enable other authorities also to have enforcement powers?
I mean, in situations where it talks about where we talk about the financing of public bodies, these are decisions that are taken at budget, and I'm not going to move into talking about a budget that hasn't happened yet. There's a lot of bodies that would be dealing with environmental, so we would have, you know, in terms of investigation of an ecocide event, Police Scotland, SEPA, Nature Scot, Coast Guard could be. We don't know what type of event it could be, whether it's marine, whether it's on land, whatever it is, depends on the location and nature of the crime. Spill at sea, we could be UK bodies involved in that as well. Say an oil spill, and you'd have you know, non-government spill response organisations as well. It's impossible for me to say what additional resource would have to go in for an event that's not happened.
I think it's fair, though, when we heard from SEPA Cabinet Secretary, just to help on the answer to that question, is that they felt they had enough resource to do what they're asked to do at the moment. The question is we might be asking them to do something else by the introduction of this bill.
That's always something that has to be taken into account.
And the fear is that they don't have enough resources to do it, and the financial memorandum doesn't allow them extra resource. Is that a concern for you?
I mean, if it's been raised by the bodies that they do not have the resource associated with what's been proposed in this bill, then that's obviously something that we'll need to look at. But it's not my bill.
Okay.
Response from the government on that is quite important because it's a concern that's been raised by different organisations. Yeah. And the other issue that's been mentioned by several organisations is that they are concerned that stronger enforcement of existing law would be as important as creating an ecocide law on top of existing law. And again, concerns about having the legal tools and the resources, because Cabinet Secretary just said this is a new piece of legislation, so it's not for you to address. But concerns have been raised that aren't
so with every piece of legislation that asks more of our public bodies, we need to take into account what resource they would need to carry out that. Of course, that's a normal part of government, and it's done budget negotiations associated with every portfolio who's got responsibility for public bodies will put those arguments forward to the Finance Secretary. And
you cut me off with the second half of the question, which is about, yes, this is new legislation, but just to put on the record, we have had concerns that existing law, there are organisations that are challenged financially to actually implement the existing legislation in terms of their existing funding. And one of the things we got in previous evidence was that there's been a doubling of public complaints, but the number of prosecutions have significantly declined. So is there an issue with existing law that needs attention as well as the consideration of ecocide? Because the two are linked. That's been suggested to us by different organisations.
If there's pressures on particular public bodies in dealing with existing laws, and of course they can come to me and they can explain what that pressure is and what it is that they need.
Well, just that's come up in evidence.
Yeah, well, you've put it on the record.
Okay.
I think we're in danger of stretching 1 to 4, but I think you've gone as far as you can on that, Sarah, if I may. Mark, you've got a brief question, I believe.
Yeah, I think you said at the beginning of the session that you would seek to amend the bill to remove the reporting. We have had some evidence, though, some views from stakeholders that they'd like to see an alternative reporting provision, which would follow any conviction to assess really how ecocide, you know, was allowed to happen, really, and to look at prevention as well going forward, how such an incident could be prevented in the future. Is that something that you would consider as an alternative to the sort of straight kind of reporting of the entire bill?
With regard to anybody that's got a different proposal in terms of reporting, I would obviously listen to them and I would see whether or not the government would support that. I don't agree with the reporting requirement in Section 10 as it is. I think it's disproportionate. I don't think it's in line with the financial memorandum. I'm not entirely sure what it adds. I am always very aware, as every, you know, I mean, say about it's just been talking about, you know, capacity and resources. That relates to government as well and to the civil service. We're putting more burdens on the civil service to be creating reports that might not actually do something or have much in them. That's a capacity that I'm taking away from something that does have a purpose. So that would be probably my bar for that. What is it adding? what is this report doing? Is this report necessary? Is it proportionate? What is it actually adding? Is it worthwhile of the time it takes for the civil service to produce this report? And what that's something that we all have to think about whenever we ask for provisions in any of these bills. Over-reporting.
So, so I think what's been put to us is more around incident reporting. So going back, if there was something like a Deepwater Horizon, incident, God forbid, in Scotland, then it would be about going back and saying, okay, well, how did this occur, given that we've got a permitting regime? What could be learnt, rather than a wider, let's assess whether this Act is working or not kind of reporting provision.
If you want to put that in an amendment, I'd be happy to look at it.
Right. Okay, thank you.
And Monica has been sitting very quietly waiting for her opportunity, and it's now come. Monica, over to you.
Thank you, Convener, and thank you to the committee for all your robust questions. Just before I ask the Cabinet Secretary a couple of questions, just to say thank you to the Scottish Government for, I would say, an open-minded approach to ecocide law. We know it's an emerging area of international and domestic law, and it's good to hear that the Scottish Government wants to play its part in a serious way. I suppose what I've heard today, Cabinet Secretary, is your desire for ecocide law to be the most severe offences and for the law to provide additionality. But you've mentioned many times, I suppose, the need to have clearer synergy between the existing regulations and ecocide law if this bill was passed. I have had a look at some of the responses from planning authorities and other stakeholders that have come in the recent days, and what strikes me is a lot of support for the general principles, but a need for clarity, reassurance, and some have said statutory guidance. Do you agree, or do you believe that perhaps in your discussions with the Planning Minister, there maybe is a need to think about what additional guidance could sit with this bill to give reassurance to decision makers that ecocide law is not about being anti-business and anti-development, but it's about taking that pro-responsibility approach and to make sure that we are protecting nature in Scotland, we're reducing pollution, and we're protecting the people of Scotland in the process?
So I think from that, I'm getting you're asking me a direct question about whether I would want to put something in the face of the bill that had guidance. I think the nature of guidance has to be that it has to be responsive and adaptable. So I wouldn't want to put anything in the face of the bill that would require primary legislation to change it. As to my, I can't comment on conversations I've had with the Planning Minister until I've had them. But I think you're right. You've heard my concerns about some parts of the bill that I would be looking to change, but of course I think I've already written to you about them. But I think we have to assure that there is a need, an additionality associated with this offence that's not already covered. One of the areas of which I have to say that I think is shows that additionality is on the penalties associated with ecocide. They are severe, extensive. They allow the courts to make a judgment on the severity of the incident or the event and the cost that there is to the environment, if you can ever quantify such a thing, but also the clean-up cost of something, or the impact it's going to cost the public purse in dealing with something that's happened. Of course, when it comes to something like ecocide, you can never really fully recover the loss. But I think that that's one of the strengths of the bill, is it's introducing the penalties that you have. Hopefully that's enough. But I think the main things that I would want you to think about as we leave here is some of the unintended consequences that have been raised by people around this table, but also the need for additionality and the dovetailing into existing legislation, and making sure that there's provisions for a fair trial, compatibility with ECHR, and indeed making sure that it is that high bar that takes it beyond the legislation that already exists.
Yeah, I think that's helpful and clear. I think that's why it shows our committees are very effective in doing their job in scrutiny, and I'll be able to address many of those points next week. Just in terms of penalties, Cabinet Secretary, you'll be aware that in the bill there is provision for orders for compensation, which may include costs of remediation or mitigation. We know that public bodies have raised concerns about resources, as have communities. And in terms of that polluter pays principle, there's a strong thread coming through in the consultation that if an accused is convicted of ecocide, there should also be a mechanism that they also have to compensate the victims of ecocide. Is this a part of the bill that you think is positive? Is there anything you would want to change in that regard?
Well, what I wouldn't want to do is do anything that constrained the discretion of the courts when they're deciding on the fines. But you're asking a specific question about a mechanism for compensation, and I'll just need to take that away. Yeah, and I've just been pointing to it about the bill. Can you leave that with me? I need to speak to my officials about the consequences of that.
Yeah, no, thank you. I just thought
I
I'd
don't have a direct
mention it.
answer for you. If it's not covered in my letter, I'll make sure that I'll respond to you on that particular point. But I want to make sure that the nature of the penalties that you're associated with it, that we're not constraining the courts on what they might be. As far as the mechanism is concerned, I'll need to look into what mechanisms already exist for that.
You. And just lastly, because I think a number of the points today have been raised are, rightly legal and technical points. But we know that Scotland does not sit in a vacuum, and ecocide law is moving quite quickly. We've seen the Environmental Crime Directive. The EU member states will all have to have it in place domestically by May of next year. Who knows who around this table will still be in the Scottish Parliament. So we're going to see quite a shift in the EU and many other countries around the world, as well as the cases that are being brought to the International Criminal Court for consideration as well. Can I ask, in your opinion, Cabinet Secretary, what message would it send if Scotland passed the bill? But equally, if we didn't pass the bill at stage one, what would that say to not just the people of Scotland, but people around the world who look to us for leadership? I
think we're talking about emotion here rather than actual legislation, and I understand why you put that to me. But if something, whatever bill it is, whether it's a government bill or whether it's a member's bill, if it doesn't progress beyond stage one, then obviously the committee will have their reasons why that's the case. The Parliament will have their reasons why that's the case. I think it's important that if the bill progresses, that it has to be fit for purpose and address a lot of the issues that's been mentioned. It's not enough just to say, oh, that sounds like a good idea. That actually has to work in law and not have unintended consequences. So if I can take the emotion out of that, I think that if Scotland is able to pass a bill that they're confident doesn't have unintended consequences and is workable and has the support of all the bodies that it affects and the people that it affects, then we'll have a good bill. It's more important to pass a good bill, not just to signal support for something that maybe has flaws in it. I think that's very important for all. Hopefully everyone will agree with me on that.
Thank you very much, Monica. And you'll get your time, I think, next week. But can I just ask one final question, very brief one? If this bill was passed, how many prosecutions would there have been in the last 10 years on ecocide?
So I don't think that we can quantify that yet. You asked that question of academic legal experts, and some of them said 11 and some of them said less, and some, so I mean, I don't have an answer to that, convener. I'm not an academic legal expert. I don't have an encyclopedic knowledge of every environmental crime that has happened in the last 20 years that you'd have to go to someone who does for that.
In fairness, I don't think anyone ever said 11. I think they might have suggested one, if any.
Maybe
so
I
think it was just a question of need, and Parliament should only, in my mind, pass laws which are needed. So that's what I'm trying to get to. Now, just before I close, I would like to apologise again for my telephone doing what it did, cutting you in mid-flow, David, but it didn't stop you coming back with a second bite of the cherry. So I apologise to the committee and to the Cabinet Secretary, and I'm disappointed to know that my wife now has a means of automatically getting my attention, whatever I'm doing. So on that note, I think I'll leave it before I get into trouble. But I'm sorry for that, and we will now move into private. But I would ask committee members to be back here for 11:15. Thank you, Cabinet Secretary and your team.